Good morning.
Good morning.
Good morning.
Mr. Nagel is here. For Francis Bolton Quintero.
I'm here.
We don't have.
Good morning, Your Honor.
Mr. Nagel, we advised you your client needed fingerprints last week.
Oh, yes, we're still working on getting that done. He went twice to try to get those done in where he's currently residing in Florida, but the gentleman wasn't there. He was advised to come back later. We can try to get that done again today.
I'm sorry. He went twice where he's residing in Florida. He can't get them done in Florida. That's the problem.
Oh, well, okay, understood.
Okay, we're on the record in the matter of the people of the state of Michigan versus Francis Bolton Quintero, file number 22-03148 FY. Council appearance.
Brian Ring on behalf of people practicing under Michigan Code Rule 8.120.
Matt Nagel on behalf of Mr. Botein, both of us appearing by Zoom, Your Honor.
The date and time set for a preliminary examination. My understanding is that there is a plea. There's an offer from the people for the defendant to plead to an added count 2 of embezzlement, $200 to $1,000, which is under Michigan compiled law 750.1743A. It's a misdemeanor. Maximum penalty 1 year and/or $2,000 in fines, or 3 times the amount embezzled plus restitution, and the people would dismiss count 1. There is no objection to sentencing under HYTA and a Killebrew agreement of no upfront jail. Is that a complete and accurate understanding of the plea offer, Mr. Nagel?
That is accurate, Your Honor.
Okay. Did your client appear in person to be arraigned?
I did not handle his arraignment. Mr. Botein, were you here in person for the arraignment?
I did it through Zoom.
Okay.
How did he get arraigned on felony via Zoom? Okay. Mr. Botein, did you understand the plea offer extended by the people?
Yes, I did.
I'm sorry?
Yes, I did.
Okay, do you want to accept that offer today?
Yes, I do.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, I will.
Thank you. You can put your hand down. Okay. And Mr. Nagel, did you go over his advisive rights with him?
We did, Your Honor.
Okay. And so, Mr. Bolton, do you understand that you have rights in this matter this criminal matter that's pending before the court that you would have to waive in order to accept this plea offer?
Yes, Your Honor.
Okay, so you would have to give up your right to the presumption of innocence. So you're innocent until proven guilty. Are you willing to waive that right today?
Yes, I will, Your Honor.
Okay, so you would also have to give up your right to have a trial. You have the right to have a jury trial, or you could have a non-jury trial. But at the time of trial, you have the right to see, hear, or question any of the witnesses that the prosecution intends to call. You have the right to call your own witnesses at trial or present evidence that you believe would further defense of the charges. You have the right to remain silent at trial and not have silence be used against you. And then you have the right to have the prosecution meet their burden, which is to prove each element of the charge of embezzlement beyond a reasonable doubt. You're willing to give up all of those rights today?
Yes, Your Honor.
Anybody threatening you to get you to waive your rights and plead guilty today?
I'm sorry, can you repeat that one more time?
Has anybody made any threats to you to get you to waive your rights today?
No, Your Honor.
Any promises being made to you in exchange for you waiving your rights?
No.
Are you currently on probation or parole?
Never been.
I'm sorry,
I've never been. No.
never been, you said?
Yes.
Okay, and you understand that a guilty plea could result in a conviction that may have impact on any immigration or travel status that you may be seeking. Do you understand that?
Yes, Your Honor.
Okay, and you understand that a guilty plea can result in a conviction that you may need to report to your current employer, or you may need to put a criminal conviction on a future job application. You understand that?
Yes, Your Honor.
Okay. Are you pleading guilty to the charge because you believe you're guilty?
Yes.
Okay. Okay, and so there is a Killebrew agreement. A Killebrew agreement is a sentencing agreement between you and the prosecution. I am not a party to that agreement. So at the time of your sentencing, if I decide that I'm going to sentence you to a term of jail time, I would give you the opportunity then to withdraw your plea, okay?
Okay.
As to the added count 2 of embezzlement, $200 to $1,000, sir, how do you plead?
Guilty.
Mr. Nagel, have a factual basis.
Yes, Your Honor. Mr. Botein, on or about October 10th of 2021, were you an employee at the Lansing Target store?
Yes, I was.
And at the time you were employed as a fulfillment expert, is that correct?
Yes.
And a fulfillment expert is somebody that works with customers and you handle merchandise, is that correct?
Yes.
And during that period, when you were an employee and on about that date, did you fraudulently remove from the store several items?
Yes, I did.
And to the best of your knowledge, did the amount of items that you removed from the store add up to more than $200 but less than $1,000?
Yes, I did.
Your Honor, I believe that satisfies the factual basis.
Any questions from the prosecution?
Just one, and that wasn't just on October, and that was over a course of several days, is that correct?
Yes.
No further questions. All right.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter will be set for sentencing. Sentencing is going to be March 17th at 8:30 in the morning via Zoom. Mr. Bolton, you need to make contact with the probation officer or the probation department, and you need to make contact no later than 9 o'clock in the morning on Tuesday.
On
You understand
Tuesday.
that?
Is there an email or a phone number or?
We'll get that to you, Mr. Botein. My office will get it to you.
Sounds good.
Okay, very good. And so typically you would be required to report in person, but because you're in Florida, I'm going to grant you an opportunity to do that remotely, but you need to make sure you make contact so that you can get your pre-sentence investigation set up, okay? They will send you some paperwork that you need to complete and you need to get back to them immediately, okay?
Perfect. Sounds good.
Okay. We don't have a restitution amount at this time, is that accurate?
Your Honor, the amount would be $1,153.24.
$1,153.
$1,153.24.
And 24 cents.
I do have one question.
What?
Yes, sir.
For the fingerprint order, I will have to make the trip to Michigan, right? I'm correct?
For your sentencing?
For my fingerprint order.
We'll figure it out.
You can't be, you cannot be fingerprinted outside of Lansing. They won't accept it for whatever reason. So it's been noted here. It looks like the magistrate noted that you lived in Miami, Florida at the time of your arraignment. And so I'm not going to order you to fly to Michigan or drive to Michigan for fingerprints at this time. Okay?
Thank you so much.
They'll need to figure something else out if they need to get fingerprints on file.
Okay.
2023.
Thank you for that, Your Honor.
So, no problem. And so I noted here the amount sought in restitution. You're going to make contact with probation within 48 hours. so they can provide the court with a pre-sentence report. And actually, Monday's a court holiday, so you need to make contact by Wednesday, not Tuesday.
Wednesday?
Wednesday at
Okay.
9 a.m.
Mm,
Okay, do you have any other questions, sir?
No, I do not.
Nothing else from the defense, Your Honor.
Anything from the prosecution?
Nothing, thank you, Your Honor.
Okay, you're all set, sir. Thank you.
Thank you, Your Honor. Have a good rest of your day.
Thank you,
Same
Your
to
Honor.
you.
I appreciate it.
No problem. The police department needs to figure out how they can get fingerprints from other states at this point in time.
Mm,
Okay,
Um,
Mr. Silverthorne, which matter are you here on? Is it Eric Odell? Or Odell?
I'm sorry, Your Honor, I was muted. Eric Odell.
Oh. Is that you, sir? Okay, I just wanted to make sure. Mr. Seacrest, who's representing him? Mr. Hess, Judge Ward.
Nobody.
Okay,
Yeah, that's.
Grant is in custody downstairs. Quentin Emerson. Okay. Well, on the record in the matter of the people of the state of Michigan versus Quentin Lanier Emerson, file number 22-03563, council appearances.
Brian Ring on behalf of people practicing under Michigan Court Rule 8.120.
Morning, Your Honor. Attorney Derek Dutch, across the public defender. I'm appearing on behalf of Mr. Colt Ryder, who is out with a medical emergency with his family. Mr. Emerson is in the courtroom standing to my left.
Okay, how are you, Mr. Emerson? Well, thank you. Today's the date and the time set for a preliminary examination. I have a note here that Mr. Emerson wants to waive his preliminary examination. Is that correct, sir? Okay, is the prosecution waiving theirs?
Yes, Your Honor, the prosecution is also unconditionally waiving the right to preliminary examination at this time.
Okay, is there a offer?
There is no offer at this time to place learning, Your Honor.
Okay, Mr. Emerson, you understand that you have the right to have a preliminary examination here in the district court.
Yes, ma'am.
You understand that at the time of the preliminary examination, you have the right to have the prosecution meet their burden, which is to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You understand that?
Yes, ma'am.
You wish to unconditionally waive that examination today?
Yes, ma'am.
So you understand the unconditional part means you can't change your mind.
Yes,
You
ma'am.
can't come back later and say, you know what, I should have had that exam.
Yes, ma'am.
Okay, once you waive it, this matter will be bound over to the circuit court. The prosecution will not be required to put on any evidence at this stage to determine probable cause. You understand that?
Yes, ma'am.
Anybody making any promises to you to get you to waive your exam?
No, ma'am.
Have you been threatened in any way in exchange for you waiving your exam? Okay. And you're waiving it freely and voluntarily?
Yes, ma'am.
Is your signature, sir?
Yes, ma'am.
Okay. Fine, you're waiving it to be made freely and voluntarily. This matter will be bound over to the circuit court for a bind over date of January 25th, 2023. You do not need to appear in court on January 25th. That's the date they get the file from this court, okay? Unless your attorney makes a motion for a arraignment at the circuit court level, you will not be arraigned there at okay? Yeah.
Okay.
Okay, your next court date will be in circuit court. It will be a pretrial, your attorney, and you will be made aware of that date, okay?
Yes, ma'am.
Bond was set at 10,000 cash surety. That will continue. Any additional matters for the record?
Nothing on behalf of people. Thank you, Your Honor.
Nothing for the defense, Your Honor. Thank you.
Thank you. You're all set, sir.
Thank you, Your Honor.
Thank you, Your Honor.
All right.
On the record, in the matter of the people of the state of Michigan versus Michael Odell, file number 22-03042. Is that you, sir?
First name.
I'm sorry, Eric Michael Odell. I do see that. Council appearances.
Brian Ring on behalf of people practicing under Michigan Court Rule 8.120.
Good morning, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Eric Michael Odell, who I think is approaching council table. Yes, he is.
He's present here in the courtroom. Today is the date and time set for a preliminary examination. My understanding is there's a request to adjourn.
That's correct, Your Honor. There are some authentic medical records that people have not been able to get access to yet, Your Honor, and I would like to see those before any determination is made on behalf of people.
Mr. Silverthorne?
Yes, I support the request. I also would like a copy of that medical report. And I spoke at length with Mr. Odell yesterday evening by phone and indicated to him my desire, and he is agreeing to waive the timeline. We would note that he's out on bond, so there is no prejudice by this delay to him.
Okay, thank you. And Mr. Odell, you understand that you had the right to have a preliminary examination within 21 days of your arraignment? Okay, and due to the pending discovery that is medical records that are being sought, are you willing to waive the timeline so that we can set it beyond the 21-day time?
Yes.
Okay, anybody threatening you to get you to waive your timeline today?
No.
Okay, we're gonna get you a new court date. Do you need a new probable cause conference or just a new preliminary examination, Mr. Silverthorne?
It's just a new preliminary examination, Your Honor.
February 3rd. February 3rd at 1:30. 8. I'm sorry, 8:30. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing on behalf of Mr. Odell. Thank you, Your Honor.
Okay, you're all set, sir. We'll get you a copy of your next court date.
Thank you, Your Honor.
The client here,
Yes, Your Honor, Mr. Jackson.
we're on the record in the matter of the people of the state of Michigan versus Melvin Jackson, file number 22-03249, council appearance.
Brian Ringo on behalf of the people practicing under Michigan Code Rule 8.120.
Morning, Your Honor. Jared Austin, appearing on behalf of Mr. Jackson. He stands present to my right.
How are you, Mr. Jackson? Today's the date and time set for a preliminary examination. My understanding is a request to adjourn.
That's correct, Your Honor. People will be seeking a 1-week adjournment. The state trooper that is necessary to witness this party. His wife's having surgery today and he's going to be out for a day with her, so he could not attend.
Mr. Austin.
Thank you, Your Honor. I know there's been a previous adjournment. However, given the brevity of this adjournment request, I would not be opposing it. As I've explained to Mr. Jackson, I think it would probably be better in his best interest for the 1-week adjournment as opposed to advocating for dismissal and starting the process all over.
I don't know that we'll do it next week. See what my schedule looks like. Okay. Sounds good. Okay, we will set this out with the time. January 19th at 9:30. January 19th at 9:30. Well, I'm gonna set it 2,000 personal recognizance. That will continue. Any additional matters for the record?
Nothing on behalf of the people. Thank you, Your Honor.
Nothing on behalf of Mr. Jackson, Your Honor. Thank you.
We'll get you a new notice to appear, okay, sir?
Yes, ma'am.
Thank you. You can have a seat. Jackson. Who's representing Eastern Court? Mr. Harris. Ms. Robinson's client is where? You should get him. That's a request to adjourn. Mr. Hess was here. Did he leave again?
I'm
Oh,
here, Your
I
Honor.
can't see him.
I'm sorry,
Okay.
it's that monitor that's in the way.
You're fine. Okay, you have Seacrest and Shakur. They're both on too.
Yes, Your Honor.
Okay, we're on the, Mr. Seacrest, are you still there?
Yes, Your Honor, I am.
Very good. We're on the record in the matter of the people of the state of Michigan versus William Seacrest, file number 22-03435 FY, council appearance.
Brian Ringo on behalf of the people practicing under Michigan Code Rule 8.120.
Thank you very much, Your Honor, and good morning. Edward Hess on behalf of Mr. Seacrest. I'm appearing in the courtroom. Mr. Seacrest is present by remote video conferencing.
Okay, Mr. Seacrest, today's the date and time set for preliminary examination. I have a plea sheet here. It says that the people are offering for you to plead guilty to an added count 2 of retail fraud, second degree under MCL 750.356D. That's a misdemeanor, maximum penalty, 1 year and or $2,000 or 3 times the amount. Thank you. and they're seeking restitution, and they will dismiss count 1. Is that a complete and accurate understanding of the offer?
It is, Your Honors. The restitution amount.
Yes, Your Honor.
I did not read it on that. It was just.
In my notes, I guess someone must have communicated restitution in the amount of $414.98 to Mr. Bigelow.
That is correct, and the defense is stipulating to that restitution amount.
That's an accurate amount.
That's an accurate amount, Your Honor.
Okay. And Mr. Seacrest, you would like to accept that offer today?
Yes, Your Honor.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Your Honor.
Thank you. You can put your hand down. Mr. Seacrest, you have the following rights. You have the right to the presumption of innocence. You are innocent until proven guilty. You have the right to have the prosecution prove each element of the charge being brought against you. They have to prove each element beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question any other witnesses that the prosecution intends to call. And you have the right to call your own witnesses to trial or present evidence that you believe would further defense to the charge being brought against you. You would need to give up each of those rights today in order to accept this offer. Do you understand that?
Yes, Your Honor.
Okay, and you want to waive those rights today?
Yes, Your Honor.
Okay. Anybody threatening you to get you to waive your rights and plead guilty to the added count 2 of retail fraud 2nd degree?
No, Your Honor.
Okay. You understand that a guilty plea could result in a conviction that may require you to report it to your current employer or to a future employer?
Yes, Your Honor.
A guilty plea could result in a conviction that may have impact on travel or immigration status you may be seeking. You understand that as well?
Yes, Your Honor.
Okay, I have a note here. You're on parole, is that correct?
Yes, Your Honor.
Okay, and have you discussed with your attorney how, if at all, this could impact your parole status?
I'm already serving out my sanctions from parole. They put me on tether for 90 days for this case. So parole, that was the sanctions they gave me.
Okay, sounds good.
I get off tether next week. I've done my 90 days.
Okay. Are you pleading guilty because you believe you're guilty?
Yes, Your Honor.
Okay, as to the added count 2 of retail fraud 2nd degree, how do you plead?
Guilty, Your Honor.
A factual basis, please.
Yes, thank you very much, Your Honor. Mr. Seacrest, on or about September the 2nd, 2022, were you at or near the location known as 725 American Road, City of Lansing, County of Hingham, State of Michigan?
Yes, sir.
And is that location known as Menards, which is a retail store?
Yes, sir.
And at that location, did you present to Menards for return a tool which you misrepresented as being a new tool that you were returning, when in fact it was an old tool that you were returning, a broken tool?
Yes, sir.
And as doing that activity, that was something that was fraudulent and intended to misrepresent and to defraud Menards from a certain amount of money. Is that correct?
Yes, sir.
And as part of this fraudulent transaction, sir, is it true that you obtained cash in the value of $414 and is it 98 cents?
It's, yes, 98 cents.
Yes, $414.98.
Yes, sir.
And as such, are you asking the court to accept your plea of guilty to retail fraud 2nd degree, having defrauded Menards of $414.98?
Yes, sir.
I have no further questions, Your Honor.
Any questions for you, Mr. Ray?
No, nothing for the people. Thank you, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. Find your plea to be made freely, voluntarily, and intelligently. Any objection to immediate sentencing?
None on behalf of the people. Thank you, Your Honor.
No objection, Your Honor. Thank you very much.
You can make allocation.
Should the defense go first, Your Honor?
Well, I don't think he's gonna make one.
Okay, all right. Thank you, Your Honor. With respect, I would respectfully ask that in this matter, Mr. Sechrist be sentenced to restitution and fines and costs. This entire situation originated with a commercial dispute that Mr. Sechrist had with Menards. He felt ripped off by them, that they wouldn't accept a return. So he figured out his own self-help way to do the return, which involved being deceitful. And he got caught, and that's why he's pleading guilty. He accepted responsibility for his actions as being deceitful. I would respectfully ask the court find that imposing a fine on Mr. Sechrist is an appropriate way to sanction him and remind him that this sort of conduct is not legal, to not be repeated, and that in the future, if he has a dispute with a merchant in this town, that the proper recourse is to resort to negotiations or to the courts, but not to self-help and not to breaking the law. Thank you, Your Honor.
Your Honor, can I speak on my behalf also?
You absolutely can.
All
You can
right,
do so now.
I made a mistake, Your Honor. I bought an auger, the engine burned up. I was in Lansing. I didn't have any other way to return the auger. Once they wouldn't accept the return because I put gasoline in the auger and used it, it was kind of like a last option. I know it was the wrong option. I spoke with my counselor about this many times, and I'm changing my ways. And I did buy a new auger, and I did put the old auger into the new auger box and return it and get my money back and keep the new auger for my own personal use. When this case, we found out I was charged with this case, parole sentenced me to 10 days in jail for the violation and 90 days on tether. I did my time in jail. I did my 90 days on tether. Last week I started a new job. It's a job that I could build a career off of. It's my future. It's one of the best jobs I've ever had. And I just would hope to ask that you take that in consideration in sentencing me. And I respect your decision. Will be fair, and I accept my punishment.
Thank you. What are you on parole for?
I'm on parole for larceny in the building, receiving and concealing stolen goods, and also retail fraud, Your Honor.
And you have a history of retail frauds, do you not?
I've had a couple of them. Yes, ma'am.
My records reflect you have at least 4 convictions of retail fraud. Does that sound accurate?
I think 2 felonies and misdemeanor. Yes, ma'am. Yes, ma'am.
Okay. Okay, and so
Hold on one second.
what do you think is gonna make me think that you've changed your life up now? Because it looks like you've been committing retail fraud since 2003.
I'm gonna tell you right now, since this has happened, I mean, I've regretted it every day for the last year. I've been completely stressed out over this. Spending time with my daughter has made me realize that I made some mistakes. Hold on, Kinsey, hold on. Your Honor, I've made some mistakes and that there's nothing I can do to change them. But from here on out, I've attended counseling. I've attended substance abuse treatment. I have done everything to get help. I talk to my counselor about it weekly. Through parole, I don't have to see counseling no more, but I seek them because I realize that I need help. And not only do I have to change the way I behave, I have to change the way I think, the way I act. My thought process is messed up, Your Honor. And it comes from a history of trauma and PTSD. And when I get in bad situations, I make horrible decisions. And I'm really trying to change that way of thinking, and I'm really seeking help to change that way of my thought process. And I'm trying to be not a burden to society and more of an asset to the community. There are multiple things I do around my area. I do community service through my church. Not community service as in like I have to do it, but like I go to the food pantry and help hand out food. I'm just trying to become an all better person, and I made a mistake, and I can't change that, but it will never happen again. I love my daughter to death, and she's my sole reason to never break a law again. I mean, I did what I did, and it's done. And I just want to get it behind me, but also I want to know that I'm seeking help, and I continue to seek help, Your Honor.
Thank you. And thank you for your candor.
Can we-
I just wanted you to understand, and it seems like you do, that it's a mindset change that's gonna have to take place if you're gonna stop committing these actions, because at this point, you have a demonstrated history that you have a cycle of this type of behavior. Only you can break the cycle. I'm glad that you're using your daughter as a motivating factor, but you also have to be self-motivated that you're not gonna make these poor decisions anymore. It's not worth it. For something that costs $400 for you to put yourself and your family and your livelihood at risk and your liberty at risk. It's just not worth it. But you're already on a parole. You already have some oversight. There is just not any meaningful reason for me to put you on further oversight by the court. It sounds like you're on track to make some corrective behavior and decisions. You got a new job. It sounds like that's a motivating factor for you. The court does not have any intention of taking you away from that or from your family. I am going to adopt the request of your counsel, which is to sentence you to fines and costs. Restitution will be ordered in the amount of $414.98 per the stipulation of the prosecution and the defense. There will be a $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost that will be assessed, plus a $400 fine that will be assessed.
Yes, Your Honor.
It's a total of $939.98. How do you intend to make payment on that, sir?
Your Honor, I can start making payments next week, Friday, when I get paid.
How much are you gonna pay next week?
I could pay $50 a week until it's paid off, or whatever you guys set. I work 40 hours a week. I make $22 an hour. So I'm not sure like how you guys calculate that.
That's completely fine. We'll note here that you'll make payments of $50 per week until paid in full beginning next week. So that'll be next week, Friday, that you'll make your first payment. Is that correct?
Yes, Your Honor.
Okay, you can make payment online using the court website. In this case number 22-03435, and you'll be able to make your payments that way, or you can mail check or money order to the court, also attaching that case number so they know where to apply it, okay?
Understood, Your Honor.
Okay, do you have any questions at this time?
No, ma'am.
Any additional matters for the record, counsel?
Nothing beyond on behalf of people. Thank you, Your Honor.
Nothing further. Thank you very much.
You're all set, sir.
Thank you, Your Honor. Have a good day, guys.
Have a good. Same to you. We're on the record in the matter of the people of the state of Michigan versus a grant. Is it? Don't mind?
Yes, ma'am.
Okay, file number 22-03178 Council appearance.
Good morning, Your Honor. Kristen Murphy on behalf of the people.
Oh, sorry. Aaron Robinson, Assistant Public Defender for Mr. Domingue, who's standing to my right.
Okay, thank you. Today's the date and time set for a preliminary examination. My understanding that there's a request for an adjournment, is that correct?
Well, Your Honor, I guess I'll say this. There were some things that I think happened that were both out of counsel's control and mine as well. It's my understanding the defendant was in quarantine at the jail and counsel was unable to speak with him because of that. This is a case where the people will not be demanding exam. So if the defendant does not want, well, if he wants his exam, we basically have to know, because we have a witness who would be traveling from out of town and certain arrangements have to be made. But if defense wishes to waive, then we obviously would not be making those arrangements. So this is one of those situations where we kind of need to know.
Oh, I do see a note here that your client was in quarantine.
That's correct, Your Honor. I did attempt to set up a meeting with him at ICJ. We made special arrangements to do a video type visit. However, when I went over there yesterday afternoon for the scheduled visit, I was denied the ability to speak to him. So at this time, we would just be asking for a brief adjournment for good cause to give me time so that I can meet with my client, go over the evidence with him, and then he can decide how he would like to proceed with the case.
Okay, Mr. Dumine, you understand that you had a due to the restraints placed on both you and your counsel due to the COVID quarantine, the court's going to find good cause to go beyond that 21-day timeline, so we can set it for a new date that gives your attorney time to review discovery and have a discussion with you so you can make an informed decision about how to formulate your defense. Okay, so we'll fix your new court date. Yes, new CCC and PE.
January 19th at 1:30.
Probable cause conference will be January 19th at 1:30 p.m.
Exam will be February 24th at 8:30.
Exam will be February 24th at 8:30 in person at the court. Okay, any additional matters for the record today?
Not from the people, Your Honor. Thank you.
None from the defense. Thank you.
Okay, you're all set, sir. Thank you. Who's representing? Gibbs? Oh, okay, Mr. Etheridge, you ready on Gibbs?
Yes, Your Honor.
We're on the record in the matter of the people of the state of Michigan versus Alfonso Gibbs. File number is 22-03549. Counsel appearance.
Brian Ring on behalf of people practicing under Michigan Code Rule 8.120.
Good morning, Your Honor. Attorney Derek Etheridge from the Office of the Public Defender. I'm substituting in for Mr. Courtroom, who had a family medical emergency, not here today. I'm representing Mr. Gibbs. Mr. Gibbs is appearing by Polycom Zoom from the Berrien County Jail.
Okay, I think we had to mute him because there was some feedback. Let's see, could you unmute yourself, Mr. Gibbs?
Can you hear me?
Can you hear? I can hear you. You can hear us?
Yes.
Very good. Today's the date and time that was set for a preliminary examination. I do have a note that we were going to treat today as a probable cause conference. And that is because last week, which was the original probable cause conference, we did not have Mr. Gibbs in court. We were notified then that he was in Berrien County Jail. So he's appearing today from Berrien County Jail. Are we continuing to examine this?
Your Honor, this time we're asking the court to allow him to wait for 21 days and have the matter reset for PCC and PE. My understanding is that the Berrien County Jail is on lockdown, COVID lockdown. I believe, based on what he told me this morning, that he thinks he will get out around January 25th in Berrien County.
26.
26, I stand correct.
26 for child support.
He's there for child support, and
Yeah.
I believe that he's has a bond that's already been posted, or a PR bond here, so there would be a hold and he'd be able to come in person. I've advised him if he does get out of jail, when he gets out of jail, to contact our office and Mr. Courtrider to inform him of such.
No, it's not.
Okay, the court already know that we have to address the timeline issue, but Mr. Gibbs, you did have the right to have a preliminary examination within 21 days of your arraignment, due to, first, the fact that the court was not originally notified that you were in Berrien County, and now due to the fact that Berrien County is under lockdown, the court's gonna find good cause to waive the 21-day timeline and give you a new court date so that you can appear for your probable cause conference and your preliminary examination, okay?
Okay. Can I ask something?
You can.
I had thought that they would already knew that I was here because when I bonded out from up there, in Mason, they came and got me from county jail to come for the child support situation.
I'm sure the county jail knew where you were, but the court didn't know.
Okay, that's how I just want to make that clear that I never.
Yeah, and so we would have had to be made aware of that in order to writ you here, but we weren't made aware of that at the time. That's not a problem. We know where you are now, and you're going to be there, you said, until January 26th.
Yeah, I'm gonna be here until January 26th.
Okay, so we'll get you a new probable cause conference as well as a new preliminary examination date now. We can talk with 26. Yeah. We can do probable cause conference February 3rd. Probable cause conference will be February 3rd at 1 p.m.
Okay.
Very nice. I'm taking February 9th. Is that a Friday? Thursday? I believe I am. That's Friday. I'm pretty sure I am. I gotta go. I help my mom. March 3rd at 9 a.m. Preliminary examination will be March 3rd at 9 o'clock in the morning in person at the court.
So that's my first court. That'll be my first court. I'm sorry.
No, your next court date is February 3rd.
February 3rd, okay.
And then you have another one on March 3rd.
Okay.
Okay. Do you have any questions today, sir?
Do I have any questions you can ask? It's kind of echoing in here. That's why I keep asking the question.
Yep, no worries. It's an echo here too. Do you have any questions for the court today?
No, I do not.
Okay. Any additional matters for the record, counsel?
Nothing on behalf of people. Thank you, Your Honor. Nothing on behalf of the defense, Your Honor. Thank you.
You're all set, Mr. Gibbs. We'll see you on February 3rd.
Excuse me, I do have one more question. When I get out, do I go to the court am I gonna be on screen or do I come in person in court?
Your probable cause conference, which is the February 3rd date, you can appear via Zoom for that. You just have to have video capabilities on your phone, but when you get out of custody of Berrien County, you need to make contact with your public defender and discuss how you're gonna move forward. They can notify the court if you would like to just continue to your exam, and then you, if that's the case, we wouldn't necessarily need to see you at all on February 3rd. But if you're gonna have your examination, you need to appear in person on March 3rd, okay?
Okay, but on March, but on February 3rd, I just go talk to my
No, you're gonna talk to your attorney before February 3rd, because on February 3rd, you need to be here for whether, and you can appear virtually on February 3rd, okay?
Okay. So either way,
You'd be here on February 3rd, you'd be here on February 3rd unless your attorney tells you otherwise, okay?
Okay,
Any other questions?
no, that's be it.
Very good.
Thank you.
You're all set then. Thank you, sir.
Okay.
Thank you. Who's handling Shakur? Is that still here? Oh, I can't see him back.
Yes, I'm behind the monitor again.
Very good. We're on the record in the matter of the people of the state of Michigan versus Xavier Martel Shakur. File number is 22-03503 FY. Council appearance.
Brian Ring, on behalf of people practicing under Michigan Court Rule 8.120.
Morning, Your Honor. Edward Hess on behalf of Mr. Shakur. I'm president of the courtroom. Mr. Shakur is present by remote video conference.
Okay, today's the date and time that is set for a preliminary examination. I have a note here that the parties are waiving exam. Is that accurate?
That is correct, Your Honor. This time people wish to unconditionally waive their preliminary examination.
That's correct, Your Honor. I respectfully ask that people place the plea offer on the record.
I have a note here that there was an offer for him to plead guilty as charged and consent to HYTA.
That is correct, Your Honor.
Okay, that's your understanding of the offer?
Yes, correct. With Mr. Shakur's age, the people would have to consent to HYTA. Is that the word that was used? Consent?
People consent to HYTA.
Thank you.
Correct.
Yes, that's totally accurate. Thank you.
Thank you. Mr. Shakur, you can hear us clearly?
Yes, I can.
Okay, and so you heard the offer that was extended by the people?
Yes, I did.
Okay, do you wish at this time to unconditionally waive your preliminary examination in the district court?
Yes, I do.
Okay, you understand the purpose of the preliminary examination?
Not 100%.
Okay, well, the purpose of the preliminary examination is your statutory right to have the prosecution put on sufficient evidence that there is sufficient probable cause that a crime was committed and sufficient probable cause to charge you with that crime. So that's their burden to make today's hearing if you decided you wanted to move forward with that hearing. You understand that?
Yes, I understand.
Okay, and probable cause is a relatively low burden, but it's still a burden that they would have to overcome. You understand that?
Yes, I do.
Okay, do you want to waive your right to have a preliminary examination in the district court?
Yes.
Okay. Is anybody threatening you or promising you anything if you waive your right to examination?
No.
Are you waiving examination today freely and voluntarily?
Yes.
And do you also understand that this waiver is unconditional? That means you can't later change your mind and say, I want to go back and have my preliminary examination. You understand that? Once you waive it, it's gone. You understand that?
Yes, I do.
Okay. I find your waiver to be made freely and voluntarily. This matter will be bound over to the circuit court. The bind over date is January 25th, 2023. You do not, Mr. Shakur, have to appear in circuit court on January 25th. January 25th is the date that they'll get the file from the district court. Your next court date is going to be in circuit court. It's going to be a pretrial. Both you and your attorney will be made aware of that date and time, okay?
Yes, ma'am.
You need to make sure you update the court if your address changes. Is that still the address on St. Joseph?
Yes, it is.
Okay. Bond in this matter was set at 2,000 personal recognizance, and it will continue. Any additional matters for the record today?
Nothing on behalf of people. Thank you, Your Honor.
Nothing further. Thank you very much, Your Honor.
Do you have any questions, Mr. Shakur?
No, I don't.
Okay, you're all set. Thank you.
Thank you. Have a nice day.
Thank you. Hartwick?
I was going to cover that for Mr. Coltrider as well. It doesn't appear she's a peer report today.
Okay, I'll issue a bench warrant bond forfeiture.
Thank you, Your Honor.
She already on bench warrant? Oh, she appeared late last week. Is that all we have for this afternoon? And those two at the afternoon are request to adjourn. Why can't Mr. Bill log in now and make a request to adjourn? Are we waiting till 1 p.m. to make the request to adjourn?
I know that Mr. Jones is locked up. I don't know if they were bringing it, if the plan was for him to be on Holly or.
Is he ready here?
Oh.
Gotcha.
That's Mr. Piper's.
Gotcha. Who's handling the restitution here?
That'd be me, Your Honor.
Have you had a conversation with the defendant's attorney?
We've been in contact the last 3 days over back and forth with the defendant's attorney and we're still trying to get that hopefully stipulated to before